Welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. Our hearing today, February 1st. Happy February to everybody. January went by so fast. It's 2 p.m. here in Conference Room 325 at the State Capitol. And thank you to my Vice Chair, the inimitable Representative Takayama. And thanks to Representative Kong and Representative Miyake for being here today. The others will be along presently. Today, if you're testifying, please try to stick to 2 minutes if you can, and I'll ask you to wrap up at that point. And also, if you're testifying via Zoom, please keep yourself muted and your video off until you testify, and then turn it off after your testimony is complete. Use the Zoom chat function only to chat with the technical staff. Please don't send me a message because I won't get it. And just chat with the technical staff if you have any issues. If you're disconnected, don't panic. Just rejoin when you can, and I'll try to fit you in to give your testimony. If the power goes off and there's a failure in the building here and we have to reschedule, we will post notice so everyone knows when we're going to meet again. If you're testifying via Zoom, please don't use any trademarked or copyrighted images because that bumps us off of YouTube, and that's a problem. And please conduct yourself with aloha, no profanity or uncivil behavior. As you know, I always like to say it's okay to disagree, but let's not be disagreeable. We're all here to do what's best for the people of Hawaii. And for nature, too. All of Hawaii. Okay, so let's go ahead and get started. First bill up, House Bill 2193, relating to fireworks. This establishes jurisdiction for the Department of Law Enforcement over enforcement of Chapter 132D relating to illegal fireworks. It establishes provisions for police and fire officers to enter premises and for the Director of Law Enforcement to inspect premises. It requires license and permit holders to maintain records and report instances of illegality in relation to fireworks. It makes an appropriation and declares that the general fund expenditure ceiling is exceeded. First up, let's have the Attorney General. First, Brenton Inouye, Deputy Attorney General. Welcome.
Hello.
Please proceed.
Good afternoon. I'm Deputy Attorney General Brenton Inouye. We are providing suggestions primarily to strengthen the Department of Law Enforcement's capability to conduct warrantless administrative searches under the continued authority of the fire departments. Second, we suggest limiting recovery for storage and disposal fines to civil penalties rather than criminal fines. And last, we suggest further defining what the term unopened case means according to this chapter. I'm available for any questions that you might have.
Great. Thank you very much, Deputy Attorney General. Next, we have Department of Law Enforcement, Mr. Michael Vincent or Mr. Regula. Good to see you.
Good afternoon, sir, and good afternoon, members of the committee.
Welcome.
Thank you. My name is Jared Ridula. I'm the Deputy Director for Law Enforcement with the Department of Law Enforcement. In the companion bill hearing, the Attorney General did voice some concerns. The department, in its testimony, is offering an HD1 to sort of address the concerns that were raised. What this bill does is create a closed distribution system for fireworks. In our state, the legislature has acted on these types of risky commodities, things like liquor, alcohol, regulated controlled substances, and has created a very strong, robust regulatory system that is closed. With this law, it helps us to create that similar closed distribution system for fireworks, and in doing so, obligates licensee holders to keep records, to make mandatory reports, and to allow the department to conduct compliance inspections. So thank you very much. We are in support of the bill.
Great. Thank you very much, Mr. Radula. Glad that DLE's got you over there. They're lucky to have you. Next, we have Larry Veray, Chairman, Pearl City Neighborhood Board, in support. Next, we have Stephanie Kendrick, Hawaiian Humane Society, in person. Welcome. The floor is yours. Please proceed.
Thank you, Chair. Stephanie Kendrick, Hawaiian Humane Society. I'd like to pick the Zoom link in case, something tragic happens and I can't get here, but happy to be here in person. You have our written testimony in support of this measure. I just wanted to really give a shout out to the task force members. Hawaiian Humane's been testifying for better control of fireworks in our state for years now, seemingly without progress a lot of the time, and we were honestly a little disappointed when Act 67 was the only measure to pass last year, but the members of the task force have really exceeded our expectations, and we're excited that this measure will give them more tools to deal with this issue and to keep explosives out of our neighborhoods, which is in the interests of animals and people. So thank you very much for your consideration.
Thank you very much. We have testimony in writing in support from the Animal Interfaith Alliance in Britain. Numerous individuals, 24 individuals in fact, in support, and one individual submitting testimony in opposition. Are there other people here or on Zoom that wish to testify on this measure, HB 2193? Please, come on up, the floor is yours. Please introduce yourself. Take your time.
Good afternoon, Chair and members. My name is Carolyn Martinez-Galoyu. I've been a resident of Hawaii since 1981, and I've only seen the fireworks problem continue to worsen. We have 2 little kitties. They were kittens at Christmas time, and it was horrendous. And the problem is, it's not just during the holidays. They start days ahead, weeks ahead. And I'm representing, I should tell you, I'm representing Rainbow Family 808. We support and defend those who can't. And so usually I'm here for children, but today it's children too, and you and I. And I'm just hoping that you support this bill and help us out. It's horrendous out there. It's not only the fireworks, it's the bombs that shake our house. And mine is a double-walled house. I live in a townhouse, and it shakes those walls. That's how bad it is. And we never know when it's coming. And there has to be some way that we can contain this, Anyway, thank you very much.
Certainly, thank you very much. And I'm not sure if we have your written testimony. If you could send it in, that'd be great. Thank you, appreciate that very much. Anyone else wishing to testify on this measure? If not, questions, members? Go ahead, have a question, and I'll follow up after you.
A question for Deputy Director.
Yes, sir.
Yeah, I have to say that, first of all, a comment that I agree with the testifiers we heard, especially Ms. Kendrick from the Humane Society, that there seems to have been a little bit of a decline in the most irritating that I find bombs that go off are those that are random. I think like on New Year's Eve, you can expect there to be explosions all through the evening and past midnight, but it's the randomness of the bombs that really, I think, annoy and bother, and for those with PTSD present a real challenge. And I have to say that in the weeks since New Year's Eve, there seems to be a decline in such explosions. And I'm interested to know what feedback you've received from the community and other people about the impact of your seizures thus far.
Yes, sir. So it's clear what we've done. This illegal fireworks are a type of contraband no different than illegal drugs. So what we've done is we've taken our methods of investigating illegal drugs and we've applied it to going after fireworks. In doing so, and in the enforcement cases that we've done so far, what we try to do is create omnipresence. We're watching. Moreover, as we all know in the room, we often in the drug game use covert operations. In doing so, people don't know that they're dealing with us. That type of omnipresence has shaken the streets. And people know now that the police are watching. And this is the type of sort of atmosphere that we have to gain. This particular measure in front of you is a very aggressive measure, an aggressive measure that allows us to close the fireworks distribution system in a way that's necessary for us to keep an eye on it. So we thank the committee for hearing this bill. But this is what we are trying to do, is create law enforcement omnipresence in the area of fireworks. And we think that we are sort of inching along and moving forward with doing that.
Thank you. My second question, if I may, Chair, is what can we expect in terms of prosecutions of those who are responsible for bringing these in?
I think there is a very good opportunity for us to get prosecutions. We are early in the investigations right now. These large seizures only occurred back in December. Sometimes investigations of these sorts can take a while for us to put together in a way that prosecutors, it will be attractive for a prosecution. These things said, investigations are ongoing daily. And we have quite a good team of people looking at this right now, very skilled investigators.
Okay, thank you. Thank you, Chair.
Sure. Other questions? If not, I have a question. So how many months was the task force in operation?
You passed the bill last year. We got together in July. The funding for it, due to the state system, it doesn't really become available till about the end of September-ish or so. We began looking on the street right around the end of September. And then in the lead up to the new year was when all the seizures occurred, and these operations are continuing daily.
So it was about 3 months, a little over 3 months of operations. And is it accurate that 35 tons was confiscated? Is that an accurate number?
It's more like 75 tons.
75 tons. 75 tons. 75 times 2,000. That's how many pounds? And that's, I mean, that's a, is that like most, how many are in a container ship? I mean, this is a lot. How many are in each container? I'm trying to help the public visualize what you've accomplished.
About 30,000 pounds.
About 30,000, say again.
About 30,000 pounds.
30,000 pounds in a container ship?
In a 40-foot intermodal container.
Okay, so 30,000 pounds in a regular 40-foot container. Okay, I'll do the math after and figure out how many containers that you've confiscated. That's, I mean, I think it's wonderful. That's 3 months. So moving forward, you know, you'll have, obviously you'll have moving forward until the 4th of July and next New Year's, a lot of time in order to continue your work. So those who said, oh, it's only, you know, they only got so many and there's still plenty that's out there, you will continue to do your work. You'll also be able to not only interdict what's coming in, I suspect that there's some illegal fireworks that are stored on the island that are then would be going out into the market. As part of your work, are you also looking at those locations? They're trying to identify those locations?
Chair, we're looking at the fireworks and the illicit fireworks problem very comprehensively.
Okay, great. And I don't want you to go any further. Oh, thanks. My smart people who are on my staff calculated 150,000 pounds were confiscated. Top notch. Okay, let me ask a question just to follow up on Vice Chair. Do you have reports on whether our anecdotal evidence is accurate, that there is a reduction in the big explosive fireworks or any other aerials and things like that that we saw?
I think it's anecdotal. It's very difficult to determine what difference is made because we simply don't know what the starting point was.
Yes.
Those things said, the effort that you saw was a result of excellent police work.
Yes. Yeah. Great. Well, we look forward to your continued success and also moving into the next stage of prosecution. So keep up your great work. Thank you very much.
Thank you, Chair.
Director Radula. Yeah. Any other questions, members? If not, let's move on to the next measure, House Bill 1888, relating to fireworks. This measure imposes a statewide limitation on consumer fireworks except by permit for use at cultural events. First up, we have testimony from Gary Lum with the Hawaii State Fire Council. Welcome. The floor is yours.
Good afternoon, Chair and committee members. I'm not Gary Lum, Socrates Batakos of the State Fire Council, and I'm representing Chair Kazuo Todd. And State Fire Council strongly supports this measure. It's our perennial ask, actually, trying to get more control of fireworks, as was discussed in the previous bill. And we think in light of some of the big fires that have happened lately that it deserves another look. Fireworks are a proven ignition source for structural and wildland fires, and we think this is another tool to gain some control of those fireworks that are being used on our islands. Thank you.
Thank you very much. Next, we have written testimony in support from the Honolulu Fire Department. We have testimony in support from the Honolulu Police Department. Gail Beckley, please proceed. Major Beckley.
Hello, can you see me?
We hear you. We don't see.
Major Gail Beckley. I'm representing the Honolulu Police Department, and we strongly support this bill too. I'm standing by for any questions.
Thank you very much. If you would please do stand by. We may have some questions for you. Thank you very much. Appreciate that, Major. Next, we have testimony in support from the Maui Fire Department, and we have testimony in opposition from Phantom Fireworks or their representative, Mr. Iosua. Welcome. The floor is yours. Please introduce yourself.
Mike Iosua on behalf of Phantom Fireworks. As the committee noted earlier, the problem is the aerial fireworks and illegal fireworks, which the task force is doing a good job of dealing with. I don't think there's any need to extend a complete ban to consumer fireworks. They're only allowed during certain holidays. Local residents like them. They're in high use during those holidays, and I think it's something that there's no data to show that or any uptick in brush fires and any type of wildland fires happens during these times as a result of the consumer fireworks. So I think this is an overstretch. We should work with the task force now to ban the illegal fireworks and just focus on that and let the folks enjoy the consumer fireworks that they do.
Thanks. And Mr. Iosua, if you could just inform the public and the committee about Phantom Fireworks. Are they a major company?
Yeah, Phantom Fireworks is a national company. They only sell consumer fireworks here in Hawaii, mostly on Oahu and the Big Island. But they're a national brand, one of the larger fireworks brands in the country.
And these are consumer fireworks that are sold to individuals who have purchased a permit?
A permit, correct, yeah.
Got it.
Yeah.
Okay.
Thanks, Chair.
Thank you. Next, we have American Promotional Events, Brian Trim, or their representative? Young?
Afternoon, Chair
Welcome.
Tarnas, Vice Chair Takayama, Myung-O on behalf of TNT Fireworks. As the previous testifier commented on, it is a cultural value for fireworks here in Hawaii. It's been here since decades, and even probably longer than that, as immigrants continue to arrive in Hawaii. As the absence of anything safe and accessible fireworks, consumer fireworks here in Hawaii, people are going to turn to the black market. And similarly to the previous bill, if there is nothing available, it is treated as contraband, and the black market does create a ability for individuals or organizations to make a profit. TNT Fireworks is a national company that operates in all islands. They do have a warehouse in Waikele, as well as a warehouse, the caves in Waikele, and a warehouse on the Big Island. But they do sell permits, operate with vendors, retailers, and making sure that they are legitimate. Happy to answer any questions.
Thank you very much. Next, we have testimony in opposition from Tina Yamaki, President of Retail Merchants of Hawaii. Not here, okay. Next, we have testimony in support from Stephanie Kendrick. Welcome. Everybody wants to see you on TV.
Stephanie Kendrick from the Hawaiian Humane Society will stand on our testimony in support of this
I
measure.
always ask, tell us the highlights of your testimony.
So I would disagree with the previous speakers. Fireworks of all kinds cause harm in our community. Even fireworks bought with permits can be misused, used at times of the year when people aren't expecting these noises to happen, explosions to go off. I have issues with using a cultural argument for something that's causing demonstrable harm. I think our culture in Hawaii is one of aloha and respect for each other, and this bill represents that, and I would encourage you to pass it.
Thank you very much. We have testimony, written testimony in support from 25 individuals, and testimony, written testimony in opposition from 6 individuals. Is there anyone here in person or on Zoom that wishes to testify on House Bill 1888? Please come on up, introduce yourself, and please proceed.
Again, my name is Carolyn Martinez-Galoyu. I represent Rainbow Family 808, and this is just in addition to my last testimony, but I will get it to you in writing. Several years ago, a bunker exploded when people were trying to get in to their stash, and they were killed. That in itself is enough to say it is dangerous. So it's not just our inconvenience. It's not just people try to put their pets, it's expensive for them who put their pets in places where they will be safe from the sound. They buy all kinds of equipment to keep their pets safe. But the whole issue is it's dangerous and it's deadly when it's misused. And so while I support those who do it legally and with licensed people that know how to do it, then that's just fine. But it's not fine what we have now currently. So I strongly support this bill. And I still feel sorry for those people who died, but it hasn't stopped others, unfortunately. Thank you very much for listening.
Thank you very much. Appreciate that. Anyone else wishing to testify on this measure? If not, questions, members? Vice Chair, please proceed.
I have a question for the State Fire Council, if I may. This bill was introduced at your request, and as you said, it's a perennial measure. I think maybe we need to clarify. The measure says that it would impose a ban on consumer fireworks, but since almost all the aerial fireworks we see are illegal already, except for the licensed commercial activities, they're already illegal. Those who use them are committing a crime. We're really talking about firecrackers, aren't we, for the most part?
Firecrackers on Oahu in the city and county of Honolulu, and showers, fountains, spinners, etc., the smaller ones that go no higher than 12 feet on the other islands.
Okay. And that leads me to my concern about the measure is that, you know, there is a legal avenue for those people who wish to use firecrackers, which is to get a permit, $25, and then you can purchase firecrackers at certain stores legally. Those who use illegal aerials, although they're already illegal, we honestly see very little enforcement of the laws against them. So in effect, what we're doing is we seem to be penalizing those who are legal users of firecrackers as opposed to doing anything more other than what the task force is doing to crack down on illegal aerials. So how do you respond to that concern?
Well, I understand that concern, and the State Fire Council, the county fire departments, has just always taken a strong stand against the regular use of fireworks, including firecrackers, as a risk. But I can understand that people have a legal permitted use of firecrackers, and that is different than the illegal arrows, bombs, etc., that are being used by other folks that are not obeying the law.
Right. Thank you. My final question is, you make reference to injuries and fires that have been caused by the use of fireworks. Are these usually caused by aerials or firecrackers?
I think both illegal use of aerials and some may be firecrackers as well too. So I don't have a definitive answer for that.
Okay, thank you. Thank you, Chair.
Sure. Other questions? Otherwise, I have some. Would you be able to gather data to help us out to draw that nexus between fire starts and what type of fireworks caused it, whether it's aerials or firecrackers?
I'm not sure that the injuries, we have the number of injuries, fatalities, et cetera, but I'm not sure that we have data saying whether they're from legal or illegal firecrackers or fireworks, but we can look into that.
I'd be interested in both the injuries as well as the fire starts. Because, I mean, anecdotally, just from my own experience, it appears that it's the aerial fireworks and the explosive devices that are the ones that are causing the injuries and the fire starts, and not the consumer fireworks. But that's just my anecdotal, conclusions based on what I see and hear. But I'd like to see if there's any data, because I looked at the data that I had available to me, and it's not disaggregated.
We can take a look at that. I hear what Chair and you and the Vice Chair are saying, and we'll see if we have data on whether the injuries, fatalities are being caused by illegal fireworks as opposed to legal ones.
Great, and as I said, it's not just, it's both the injuries as well as the fire starts that I'm interested in.
Okay.
Yeah.
We'll do this.
That would be great.
So.
If you could help us out with that, that would help.
Okay, thank you.
Great, thank you very much. Any other questions, members? If not, I beg the indulgence of the committee to go back to the first measure. I needed to ask a question of DLE that I forgot to ask. So let me briefly go back. Mr. Vincent, Director, thank you. In your proposed HD1 with the amendments that you included, were you able, do you feel confident that you've addressed the concerns that the Attorney General brought up in
Yes, sir.
the earlier ones, in their comments?
The HD1, the addition, actually comes from the administration bill, which came to me like late, the evening before the governor's state of the state, so we didn't get a chance to get that moving through. So that language actually comes from the administration bill, which was something that we'd been working with the Attorney General.
Okay, so your proposed HD1 brings really the language from the administration bill, utilizes the appropriation that's in that bill, that is in our HB 2193, and you're confident that that language addresses the AG's concerns?
That's correct. The only thing is we left in the criminal penalty is still in there. We believe that if somebody is convicted for violating the law, that one of the options for the judge should be a requirement that they pay for any cleanup and disposal costs. And that's why we wanted that left in on the criminal side. But otherwise, everything is addresses all the Attorney General's concerns.
Okay. When we were looking through it, we weren't quite sure, but it seemed like there may be some overlap between the new administrative inspection section and the amendments made on Section 3 of the bill. But I'm assuming that you've gone over this carefully with the AGs, so that you're confident it's okay.
Yeah, yes, sir. I mean, there's an extra section that came in from the Attorney General, but basically it's replacing just that part of your folks' bill.
Okay, okay. Well, this still has a ways to go, so
yes, sir.
If AG would look at this again as it goes forward, this first bill, HB 2193, goes on to Finance and then, of course, over to the Senate. So if you could keep your eye on this and just make sure it's consistent all the way through, that'd be great.
Yes, sir. Thank you.
Okay, thank you very much. All right, there being no further questions on either 2193 or 1888, let's move on to the next measure. House Bill 1865. Switching gears here, we're now talking about making an appropriation for the Career Criminal Prosecution Program. This measure appropriates money to the Department of Prosecuting Attorney, City and County of Honolulu, for the Career Criminal Prosecution Unit. First up, we have testimony from the Department of Prosecuting Attorney, City and County of Honolulu. Welcome. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the House Committee on Judiciary and Hawaiian Affairs. I'm Paul Mao. I'm the Chief of Staff for the Department of the Prosecuting Attorney. You know, back in 1979, excuse me, the Career Criminal Program was created by the legislature as part of a legislative mandate to address the disproportionate amount of serious crimes committed by a relatively small number of defendants who commit multiple and repeat felony offenses. So these people are commonly referred to as career criminals. You know, the program was originally envisioned to provide full funding for county career criminal units across the state. In recent years, the department's career criminal prosecution unit had to be scaled back due to insufficient funding to fund the entirety of the division and maintain full staffing. Money spent on this program is an efficient use of our resources because it provides for swift and effective justice to address some of Oahu's most worrisome individuals, the persons that repeatedly commit crimes despite the fact being on probation or parole or even serving time. It reduces heavy caseloads and long court delays that are caused when we cannot provide for enough deputies and staff to support the unit. So with your support, the department would like to continue to have the resources necessary to help protect our public from these career criminals. And for those reasons, the Department of the Prosecuting Attorney strongly supports the passage of HB 1865. I'm open for questions.
Thank you. And just for everyone to know, you've included in your testimony the request, the amount needed to maintain operations for fiscal year
Yes.
24-25 is?
Supplemental amount is $747,267. That's in our written testimony.
Yep,
Yes.
just want to make sure everyone hears that. And as you said, this accounts for the difference between actual costs and the costs covered by funding from the Department of the Attorney General and the City and County of Honolulu.
That is correct.
Okay. All right, thank you very much. If you could hang out and wait for questions, we might have some.
Okay.
Thank you very much, appreciate it. Next, moving on, we have testimony from Tina Yamaki, Retail Merchants of Hawaii. Nope. And then we have testimony in writing in support from Dara Carlin, individual. Is there anyone else wishing to testify on House Bill 1865? If not, questions, members? Yes, Representative Ganadin.
To Mr. Mao, with the Office of the Prosecutor.
Yes, sir.
Good afternoon. I don't see in the statute, and maybe I don't know the Hawaii Revised Statutes well enough, how career criminal is defined. So is it defined by like how many charges, length of charges, types of charges?
We have a screening criteria that helps to define that. And so within the cases, and this is an understanding between the prosecutor's office and the police. So for example, the general rule is as follows, and there's a number of exceptions. If a suspect was on parole at the time a new felony offense was committed. Second would be if the suspect was on felony probation at the time a new felony offense was committed, or if the suspect is a convicted felon and the proposed new charges include a felon in possession firearm offense under HRS 134-7B. So that's the general criteria. There's a number of exceptions. I'll give you a couple. So in the cases where a person both qualifies under career criminal but also might be, say, a sex offender, the sex offender team, instead of career criminal, might handle a case like that. We also have an elder abuse section in our department, and they may be handling those types of cases. There's a number of different exceptions, but the general rule is the one that I stated.
Yeah. So, Chair, I'm going to,
yes, please,
a couple follow-ups. Okay, all right. You just mentioned 2 of the 3 criteria have to do with probation and parole. We just heard, this committee just heard yesterday that Hawaii has the longest term of probation in America and that there are over 15,000 people in the state of Hawaii that are on probation. Mm-hmm. So these people committing crimes while on a lengthy probation could be considered career criminals. Is that correct?
If they're under a felony probation at the time when they commit a felony offense, it would meet that second criteria, correct?
All right. There are a variety of ways that the county prosecutors communicate with federal prosecutors. And just, reading the news and paying attention to what's happened here in Hawaii in the last several years, many of these cases have been, given to federal offices. For example, the quite lengthy number of defendants that came through the Kealoha cases. Of course, could they have been prosecuted as career criminals?
It could have. It depends on the situation, but yeah, it's possible.
In that instance, would you have processed them through this career criminal tract, or would you have, just handed the entire case to the feds?
It really depends, because in certain cases, what the federal might be able to do, because they have sentencing guidelines, there may be a stiffer penalty, for example, for a person like that. And so there may be a case where HPD had brought it to the feds instead of us, if we're both, capable of charging a case.
All right. So how many staff members would this amount cover? So like lawyers and staffers?
The ideal, I guess, that we're trying to achieve is a full team of career criminal prosecutors is about 8 to 10 deputy prosecutors. And, depending, these are prosecutors, they're not entry-level prosecutors, of course. They're prosecutors that have worked their way through our department. They develop skills first, in misdemeanors. They work through to felony. They learn how to screen. And then they become persons that can be assigned to career criminal prosecution. So they're more experienced. They can handle certain cases because they have to be able to. They have to make charging decisions. But yeah.
I understand that. So experienced prosecuting attorneys who normally handle A and B felonies, usually here at the circuit court, can you just continue to direct them to these kinds of cases, which might still engender these advanced sentencing laws or parole violations? I mean, is this work already being done by the prosecutor's office?
Well, it's been done, since the time the creation of this program. We do our best, but what we're saying is, in order to do our very best at this job, we require, as full of funding as we can possibly do for this team, keeping in mind that these are very serious offenders.
Thank you.
Okay, thank you. Other questions, members? I have a question.
Please.
Last week at the briefing before the Ways and Means Committee in the Senate, the Attorney General informed us that the prosecuting attorney of the City County of Honolulu has decided that you're not going to prosecute any state cases, which I understand is about 600 cases or so.
Yeah.
But here you're asking us for an appropriation in this bill and the next bill, combined $1.4 million. So why are we appropriating funds to you to do these things when you've just said you're not going to prosecute any state cases? It's troubling.
Well, I think we need to have some perspective on the kind of cases. When you talk about the 600 cases that you're referring to, state cases in origin, these are primarily misdemeanors, petties, citations. When we're dealing with career criminal, you're dealing not only with felonies. These are serious felonies committed by people who've already been sentenced previously. They've been put on probation, they've been put on parole, they've been incarcerated. They're the worst of our offenders. What you're really talking about in the state cases is they're not really comparable. Not every case is alike. So when you say 600 cases, we're not really talking much in terms of felony cases. You're talking about misdemeanors and below. All of these cases with career criminal are serious felony cases.
Okay, so the 600 cases do not include felonies?
No. Well, there are felonies, but the number of felony cases that I understand that we turned over to AGs is very small, if not zero, because, I was told that there were some cases that we used to get referral or handle from state narcotics, from NED. Those cases now are going to be handled by them, but there's very few that were referred from state narcotics to our department. So it's important to keep in mind, the Attorney General, even before this October communication, with the Attorney General, they were already doing several state cases. For example, escapes, from Department of Public Safety. That's not added. That's not part, it shouldn't be part of the 600 count. The 600 count, if it is 600 cases, and I don't know if that's a fact, I was told that the number of cases that come out to about 50 cases, per month, maybe, as far as citations.
So these are citations and misdemeanors,
citations,
petty misdemeanors.
And the like. That's the kind of cases that it's composed of. You're not talking about 600 career criminals, being turned over to the Attorney General.
Got it. Okay. Okay, thank you. Other questions, members? Yes, Vice Chair, please proceed.
If I could follow up, Mr. Mo. You must have made some estimate in terms of cost savings that this action would spare you in terms of your budget. How much money are you saving by not doing state cases?
I have to say, we didn't exactly look at the cost savings of that because, and it's hard to calculate because there's a lot of people involved, both in the clerical and the state. I'll tell you, what does factor into that is because they're coming from state origination, and a lot of it has to do with cooperation working with a state department. One of the difficulties that our office has had is you got to work through, a state agency, and we don't always have regular contact, with state agencies when they're involved in those types, where they're maybe even the victim of a case. I'll tell you who is involved with those kinds of, departments. It's the Attorney General. The Attorney General is assigned as the attorneys for all of the state departments. They regularly work with these departments. They have consistent communications that go on between their office and these various state agencies. When we have a case sometimes that deals with this, a citation level one, what it's going to require is for us as Department of Prosecuting Attorney to contact somebody at AGs and ask for their assistance to kind of go, to these AGs, to get the information about an agency.
So before you took this step, was there an effort to discuss this with the Attorney General in a collaborative manner
Yes.
to improve the communication between your office and that of the AGs?
We communicated with them. There was several discussions, from my understanding, between, I guess, the administration, on the matter. There were some meetings where the Attorney General's office came to visit us to talk about how they would implement the program. Our staff assisted the Attorney General representatives. They were both attorneys and clerical, and also provided information of how to handle these cases in court.
Okay, thank you. Thank you, Chair.
Thank you. If you are able to estimate this cost savings, that would be valuable for us to know, because we're trying to figure out a very tight budget.
Yeah,
And
sure.
I know you're asking for funds here, and it would just
Yeah.
help us understand it.
One moment, and maybe this will help give us some perspective on this. I think I had one other piece of information that somebody provided me. It's in the same relative time period, say, of these 600 cases, since the turnover. You got to keep in mind that the Department of the Prosecuting Attorney handles 14,000 of these kinds of cases, in their misdemeanor traffic division. So, I mean, as a percentage, it's not a high percentage of the cases in terms of the cost, but in terms of how, the state is better positioned in trying to assist with this, it's better for them to do it because of the thing that I said, which is that they have a regular communication and representation between, their agencies. It
Okay,
makes
so
it
you're saying
easier.
14,000 misdemeanor cases from the city and county of Honolulu, And you.
Versus 600.
Versus
right?
600 misdemeanors or citations from the state.
Yes.
Okay. Okay.
All right.
Thank you.
Thank you.
Any other questions? If not, let's move on. Next, we
I guess I'll
have
stay up.
House Bill 1866, making an appropriation to the Department of the Prosecuting Attorney for the Victim Witness Assistance Program. So first up, we have Mr. Mao, Chief of Staff,
Yes.
Prosecuting
Thank you.
Attorney. Please
Thank
proceed.
you, Chair. So the purpose of HB 1866, of course, is to provide funding in the amount of $736,785. And the legislature has supported the Victim Witness Assistance Program since 1983. In 1986, the legislature enacted HRS 28, Section 28-111. The purpose of that section, of course, was whose purpose shall be to provide information, assistance, and support services to the victims and witnesses of crimes committed in the state. Now, the program is administered by the Department of the Attorney General. All the different counties, work with the Department of the Attorney General after you folks allocate funds to this program. And, there's several kinds of services that the funding provides. It provides for salaries, of course, but also a good chunk of it provides to subcontractors that provide direct services to victims. So I'll give you an example. Sex Abuse Treatment Center, is a place that you would use this type of funding in order to help victims of crime. It provides for equipment for victim witness counselors so that they can be in communication with victims. It could be, cell phones and the like. It provides interpretive services also, for victims of crime. So we have many, persons that don't speak English and they require interpretive services to help communicate, how a crime was committed and facilitate communication between them and a victim witness counselor. The bottom line of Victim Witness Program is the prosecuting attorney uses its resources and its program to help individuals, victims of crime, through the court process, because it can be oftentimes confusing, it could be very intimidating, scary, and our counselors are there, to help provide these kinds of services, to talk with them, guide them through the courts, in these cases. Thanks.
Thank you very much. Next, we have testimony and support from Derek Carlin. Is there anyone else here wishing to testify on House Bill 1866? If not, questions, members? Hearing none, we'll move on. Thank you very much.
Thank you very
Appreciate
much.
it. Okay, next bill, House Bill 1968, relating to sexual abuse of minors. This bill expands the time period by which a civil action for childhood sexual abuse may be initiated. It authorizes a court to require personnel of legal entities to undergo training on trauma-informed response. First up, we have testimony from the Attorney General. Welcome.
Good afternoon, Chair Tarnas and members of the committee. I am Deputy Attorney General Lee Kwok, and I represent our department with respect to House Bill 1968. While our office does not discount the right of survivors of sexual abuse to initiate lawsuits and seek their own justice, we do have concerns with quadrupling the time period contained in the proposed statute of limitations. As reflected in our written testimony, expanding the statute of limitations by decades will compromise the availability as well as the reliability of evidence in these cases. Under these evidentiary constraints, it becomes next to impossible for the state to defend lawsuits and litigation in this, of this nature. Thank you for the opportunity to comment.
Thank you very much. Next, we have testimony in support from the Sex Abuse Treatment Center. Lynn Costales Matsuoka. Next, we have testimony from Carolyn Galoyuch. We got your testimony for this one. Please join us. Come on up.
Hello, my name is Carolyn Martinez Galoyu. I am an aged out social worker and a civil rights activist. And I've been involved in a way with this problem since 1988 when I was in Europe. And word came to us that Bishop Joseph Ferrario was accused of sexually abusing one minor. At first, I couldn't believe it. I thought of him as a man of integrity, charisma, and guess what? He is. It takes charisma to be a pedophile, to be a rapist. You groom your people. But I've been over this so many times, but I don't want you to miss out on the fact that these children certainly don't have the words or whatever when it happens to them. They are ingrained, they are brainwashed by society to think that people in authority want only good for them and to safeguard them. I learned over my years, I'm 77, that this does not hold true. And this is just one document that I have from 2018. It lists all, one page, single-spaced, of all the pedophiles and rapists that have been accused and brought to some sort of justice. I knew one in Sicily, and that's where my gut turned on me. It was a pastor. I knew him. He would be invited to dinner and take his children and go up and hear their nightly prayers. What wonderful thing we Catholics thought about that, only to find out later this man now lives in Leavenworth.
If you could summarize, I know
Okay.
this is tragic.
I know this is really
very tragic, and I
Okay,
appreciate your testimony, but if you could summarize, that'd be great.
I would like to see people take more and don't let the pedophiles and the rapists run this state. And that's what I want you to do. I want you to amend the bill to completely remove the statutes of limitations from our books and to insert in this bill not only sex assault, because some people think that's, and put sex assault / rape, so people understand the severity of this. But I thank you very much. I have one thing to end
Quickly,
with.
please.
I'm coming out. Today is the first day I have announced that I am Hawaii's first representative to freedom from religious. That means I'm a free thinker. That means if you don't like that term, I'm an atheist.
Thank you very much. I appreciate your testimony on this very challenging issue. Next, we have testimony in writing from numerous people, 24 people in support. And we also have some people here in person and on Zoom. First up, Evan Oye, Hawaii Association of Justice. Please come on up. Everyone wants to see you on TV. So please introduce yourself and briefly summarize your testimony.
Thank you, Chair. Good afternoon, Chair, Vice Chair, members of the committee. Evan Oye on behalf of the Hawaii Association for Justice. We stand in strong support of this measure, and just simply because it increases the access to justice for victims. I think it extends the period until about, the victim reaches 50 years old, from my understanding, and then from 3 to 5, it increases it from 3 to 5 years. So just a little bit more time to really process the reality of what they may be going through and having it being a difficult process to come forward. So we do support this measure, and I will be available for any questions.
Very good. Thank you, sir. Next, we have testimony from Michael Goloyu on Zoom. Please proceed.
Good afternoon. My name is Michael Goloyu Jr. I'm representing the Stonewall Caucus of the Democratic Party of Hawaii. This has been a priority for the Stonewall Caucus since the original law sunset that removed the statute of limitations for those survivors of childhood sex abuse. So the Attorney General does not need to worry about what may or may not happen They were able to handle it then. They'll be able to handle it if you remove the statute of limitations, is what we asked for in our testimony. If you stood up and cheered when E. Jean Carroll got her justice, then you need to support our amendments. Because as it stands right now, E. Jean Carroll could never get justice here in Hawaii with the way our laws. And we know she wasn't sexually abused as a minor. She was sexually abused as an adult. And once they removed the statute of limitations in New York, she was able to move forward and go after her predator. And if E. Jean Carroll can go after and get justice from one of the most powerful people in the United States, survivors of sexual abuse should be able to come and get justice here in Hawaii. And that's just not the case. Again, we don't need to study it. We don't need a task force. We've already done this and nothing crumbled. The sky did not fall. I know those that protect sexual predators can go out and hire lobbyists. Survivors cannot. They get advocates like me and other organizations that come forward to step up and ask you to do the right thing, to do what's right for Hawaii, do what's right for our keiki, and protect them and allow them to seek justice. And putting a clock on someone's ability to seek justice is just not fair. Other states have done it, removed their statute of limitations, and their states have not fallen. They have not lost. Their attorney generals are still able to do their job. So we encourage you to do this, do the right thing, and don't no longer make Hawaii a safe haven for pedophiles. Mahalo.
Thank you very much. Is there anyone else here or on Zoom wishing to testify on this bill, House Bill 1968? If not, questions, members? Quick question of Mr. Evan Oye. You heard the testimony from the Attorney General. From your experience as an attorney who works in these sort of cases, is it possible to bring a successful case with and have a fair trial, even if it's years ago?
I mean, I think that just allowing the victims the ability to bring forth their case and bring forth the evidence they are able to produce during this time, I think it just opens the window to allow them to do that. I can't speak to the likelihood of whether their case will be successful or not. I can just speak to just the access for their ability to bring it if they are able to gather enough evidence to prove their claims in court.
Okay.
Yeah.
All right. Thank you. Any other questions, members? If not, thanks very much. Let's move on to the next measure. House Bill 2230 relating to law enforcement. This bill requires the Law Enforcement Standards Board to develop and each department employing law enforcement officers to implement a structured health intervention program to support law enforcement officers' physical and mental health. First up, we have testimony with comments from Michael Vincent, State of Hawaii Department of Law Enforcement.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. Yeah, we just submitted some comments. The bill paints the picture of the garbage that law enforcement officers have to deal with, the baggage that they accumulate during their career, both physically, emotionally, mentally, and it's kind of there. We support strongly the wellness of officers. Some of our concerns go to how is something like this implemented in a mandatory manner with the departments, and putting it with the standards board. We're not quite sure that's where to put it, but if it's there, how do we structure it with the departments? You're talking about, so for example, some of the things we're looking at some incentives for the deputies. One of them being, if you pass the physical agility test every year, here's some money, just to help keep you in shape. We have a very good peer support program that we'd like to make better. But if you're going to mandate things, now we have to, do we now have to give them time during the workday to go to the gym? How do you deal with the workers' comp? When they're working out, you now have, you've taken officers off the street. The bill talks about requiring certain types of training. Well, martial arts, there's a lot of martial arts that violate our policy and actually are illegal for police officers to use. So it gets into some of the details of how would you require something like this for the departments. So we have defensive tactics and training. And, you know, the deputies come in, and those with jiu-jitsu backgrounds, you know what? They all know how to do a chokehold. But you know what we're not allowed to do? Chokeholds. And so it's a matter of scaling and throttling some of that back, teaching new techniques, but it's not really considered martial arts. So it's some of those things that need to be, you know, dealt with. And so, for example, in-service training with the sheriff. So during this prior year, this past year anyway, 2 days of it was dedicated to physical defensive tactics. They were down in the dojo and actually getting sweaty and working. We encourage the deputies to take care of themselves. I see the benefits of it. Forcing me to go through recruit class, lost 30-something pounds, you know, I'm doing good. But we're not quite sure how to mandate the details and stay out of trouble.
Okay.
Thank you.
Thank you very much. Next, we have testimony and support from the Office of Wellness and Resilience, Office of the Governor. Welcome. Please introduce yourself and proceed.
Aloha Chair Tarnas, aloha Vice Chair Takayama. My name is Naomi Leipold. I am with the Office of Wellness and Resilience in the Governor's Office. I am here on behalf of our Director, Tia Hartsock. She apologizes that she cannot be here today. We submitted supportive testimony, and we stand by our testimony. I am here for any questions. Thank you for this opportunity.
Thank you. Next, we have written testimony in support from Robert Kavako of Shopo, the State of Hawaii Organization of Police Officers. Testimony and support from Derek Harlan, and testimony and support from Sienna Molina. Is there anyone else here wishing to testify on House Bill 2230? If not, questions, members. Representative Ganadin, please proceed.
To the Department of Law Enforcement. Well, good afternoon. I had the opportunity to author this bill, and surprised I got the support of the SHOPO. I've heard on the radio and in the media that your department is hiring. How many open positions are you seeking to fill?
I believe we have about 60-something positions right now open.
Statewide?
Statewide, yes, sir.
This bill would also affect, of course, police officers.
Yes.
I know you're not with the county police, but do you know about how many positions are open statewide for police?
I don't know, but I know that every department in the state is short, and they're having a hard time filling them.
Would about 400 be an accurate number from the meetings you've been in?
I've seen a number around there, yes.
About 400 people, right? So close to, let's say, 500 law enforcement officers that we're seeking statewide to fill. Would that be about fair?
Yeah, it'd be fair estimate.
Okay. Would it be fair to say that young people who are seeking employment with law enforcement, they are coming into the career with new expectations about mental health?
Oh, yes. There is a real need to be able to take care of inside. First off, if things aren't good at home, they're not going to be good here or at work. If things are not good here, they're not going to be good at work. They need to be good inside. If you want to see when officers get in trouble, a lot of the times it's because something is wrong in here. And, you know, bad decisions come from things that are wrong on the inside and possibly at home. So if things aren't good, we're at a higher risk for our officers and the public. So yes, wellness in all its forms is very important. I went to a training facility in Gilbert, Arizona on a trip last year. And they actually have 4 people full-time at this facility for peer support. 2 for the fire and 2 for it was a combined fire and law enforcement. 2 for each side, full-time, to deal with it. It's that important.
And how many people are doing this full-time here in the state of Hawaii?
I don't know about the police departments. We have, our officers are actually, it's an additional duty. Officers volunteer to participate in the peer support program, and they get training, and it's kind of in addition. So it's, you know, hey, we got a deputy who's struggling, and somehow they get them to talk to them. There's some protections in the law that allow them to talk freely with their peer support officers. Then that is not used in administrative proceedings, so that there is some freedom for them to communicate without the fear of, you know, I don't want to say anything to you because it's going to get me fired. So it's really important that they be able to talk and communicate. We are constantly looking, new department, but as long as I've known the deputies and worked with them, they're always looking for new deputies. We have a deputy that came out from not this prior class, but the class before, on the Big Island, for example, getting her in the program. We're waiting for a training to open up so that we can send her. It's a matter of, there are people who want to do this, and it's getting the right people to do it, and there are people who want to participate, but it is kind of in addition to the regular assignments.
Regarding physical training, we've noticed in departments across the United States,
yep, it's common.
Changes in significant changes in training regarding arrest and detainment as a result of protests from the George Floyd incident.
Yes.
And from 2020 on, many of those things have been put into county and state statutes.
Yes.
Do you think it would be more effective to train officers through better techniques of physically handling suspects, or should we put it into statute mandating these things?
They're already doing it, you know. So I can't speak for the police departments, but I know they're doing it. I know what I went through for 6 weeks in recruit class, and every day it's very specific. Be very careful doing this. This is how you can do it. No knees on the neck. Put your knees on the shoulder blades. You know, there are things to do to keep them safe. And it isn't just the physical arrest and control tactics. It goes to, and there's a number of bills dealing with crisis intervention, de-escalation, and it's how do you interact with your encounters or your suspects or the people that you're working with. There's a lot more going into, and you know, the courts are now requiring a lot more. Last year, the legislature passed an act that requires de-escalation and crisis intervention. So there are things that are in the training. So in service, the annual in-service training, very specific, you know, day dedicated to de-escalation and crisis intervention. I was participating in that as, you know, the person in crisis, and it was interesting watching the deputies work through the scenario. And there's some that really get it, they really understand it, and there's some that, you know, we need to work with them. And so we're actually looking at 2 full days of this year's in-service, possibly dedicating it specifically to de-escalation and crisis intervention. So it's more than just, you know, your hands-on part. It's as you're walking up. There's a whole range of how are you going to handle the situation.
Thank you so much.
Okay, thank you.
Thank you. Other questions? If not, I have a question. What programs are you already, that you've already got in place? I mean, you've described some of them already, but are there any other programs you have in place that you have not yet described? I just give you an opportunity.
In relation to, I mean, we have one for the next bill. But,
health and wellness, trauma-informed, basically addressing the law enforcement officers' physical and mental health. Any other programs that you have?
Nothing specific,
okay,
other than, you know, what we can get them in the in-service and try to encourage,
okay,
through day-to-day, the peer support group. We are looking at doing a lot more community-facing and get deputies doing more feel-good stuff for the community,
okay,
to give them other opportunities. But I'm looking all the time at, is there things we can do to help in this area? And I know there's things that we can do, and we will eventually get there.
okay. In the bill, it says no later than blank number of days after the effective date of this act, the board shall develop, and each department employing law enforcement officer shall implement a structured health intervention program that supports law enforcement officers' physical and mental health. And then it goes on to describe what that program should be. You've read the bill. If we were to move this forward, this measure forward, how many days do you think you would need in order to put together such a program?
I think the first step is when could the board act? So law enforcement standard boards, a similar question came up on another bill last week or recently. And they haven't even done their rules yet. So the year that was kind of tossed out was possibly sometime in 26, where they would be able to have things. And I'm not speaking for the board, I'm not on the board, it's just in conversation that was, possibly. But the reality is if this was passed, we would already start looking at it and what we would do. Because on the training side, our people in our training division are very aggressive. I mean, we had a situation come up last week. We just had a meeting on a subject, and they had already gone out since then and already done what online training was available for that subject, even though we're not there yet.
Yeah.
So I think if the bill were passed requiring the standard boards to come up with their policy, we wouldn't wait to get something stood up.
But you're saying that if, would you say 6 months, for the Law Enforcement Standards Board to be able to develop this program?
I have no idea for them. Like I said, they haven't even got their rules going.
Okay. Maybe what I could do is if the committee decides to move it forward, we may decide to keep it blank, but I would look to you to communicate with the Law Enforcement Standards Board to see how long it might take them to do this so that we could fill in that blank. Because that's an unknown that's in the bill we didn't fill out.
Okay.
Okay, great, thank you.
Thank you.
I'd like to ask the question of the Office of Wellness. Office of Wellness and Resilience, Office of the Governor. Thank you for being here.
Yes.
And I note from your testimony that you are working to start with our state workforce and explore avenues to increase access and availability to mental, behavioral, social, and emotional health services and support. So if you were to look at this bill, this is right in line with what you want to do.
Yes.
Would you be able to work with the Department of Law Enforcement to assist them to develop programs that are things that they could implement?
Yes, we're very excited about any opportunity that addresses our state workforce well-being, and like the DLE representative here suggested, peer-to-peer support being one of them. Our office was established to help other state departments create such programs. So we would be in support, whether it's technical assistance or training. This is one of our mandates, why our office was stood up. So we would be very happy to assist in this effort as well.
Thank you. And I would encourage you to talk with the Department of Law Enforcement already, not wait for the bill.
Yes.
But they're already working on it. Clearly, the director said he's committed to doing this, and they're already working on it. And if you can assist them to move forward, it would be, we would certainly appreciate it.
Absolutely.
Even during the legislative session while we continue to consider this measure.
Yes, thank you. And yes, I'll relay this back to our director so that level of conversation can start happening as well from ours.
Thank you. Appreciate it very much. Thanks very much. Any other questions, members? If not, let's move on to the next measure. House Bill 2231, relating to law enforcement. This bill establishes as a goal of the state the increased representation of female law enforcement officers in the state by 2030. It requires each law enforcement agency to recruit law enforcement officers from diverse backgrounds. First up, we have testimony from the Department of Law Enforcement. Thank you for being here, Mr. Vincent. Deputy Director.
Glad to be here, sir. We have a disproportionate number of women officers in our ranks, and we recognize that. Last week before, anyway, I have already put out a request to the sheriff for names of women deputies who can help us on a group, whatever, a working group, to actually look for ways to get more women on the force. Yeah, you're talking about a career that is typically male-driven, and you get in the room with a bunch of alpha males, and things get interesting. But it's some of the women deputies that we have are just amazing. The community needs to see them. I mean, there's this commercial. The first time I saw it was at I think one of the movie theaters, and one of our deputies is there. And if those of you that work here, she's assigned here, and yeah, just amazing. We will be sending a few people to a workshop sometime in the next few months specifically on this subject. How do we recruit and retain our women officers? Because they have value. We absolutely need them. The other spectrum, I think we're okay across all the rest, but in that area we are lacking, and we are looking at ways to do this. So yeah, we're in support of your measure, and even the benchmarks. I mean, got a real low benchmark, so it's going to go up. It's going to get better. So.
Thank you. Thanks very much. Next, we have testimony in support from the Honolulu Police Department. Next, testimony in support from the State of Hawaii Organization of Police Officers. Testimony in support from ACLU of Hawaii. And then testimony in opposition from two individuals, Ryan Willis and Victor Ramos. And testimony in support from Bevan Parker Evans. Is there anyone else here wishing to testify on House Bill 2231? Yes, please come on up, Ms. Goliuk.
Carolyn Martinez-Goloyu from Rainbow Family 808. I'm a civil rights activist. My pen says feminist. That gives you an idea of what I'm going to say. I'm going to say there are too few women in places of authority, and if this is one place that we could make a headway, that would be wonderful. We had a wonderful chief of police that was female. Under her tutelage, we opened up the rape kits that had been closed for ages. That's what women can do. They not only think of themselves, but they think of the children and the men and the fathers and the brothers and so on. So they would be a great addition to this body, and I will send you testimony on it.
Thank you. I appreciate that very much. Thank you. Anyone else wishing to provide testimony on this measure? If not, questions, members. I do have a question for Mr. Vincent, Deputy Director. And
yes, sir.
One of our members and our staff met with other chiefs of police from around the state, and I understand one of the comments from one of the chiefs was there's just no way we could meet 30% by 2030, just looking at the numbers. It'd be so tough. They suggested as an alternative that we place in here the goal of 30% of each recruitment class are women as a goal. And I think, Representative Ganadin might be able to speak to this in more detail, but what would you think of that? You apparently didn't have any trouble with
because
30% of the entire workforce by 2030.
Yeah, because I don't see anything in the bill that says if 30% are not in your number, you can't move forward. That would be a problem. If you have a recruit class of, say, 15, and 5 of them have to be women, okay, that creates a problem. I mean, because the recruitment and the actual numbers we get are not, it's different. So I look at the bill and it's a goal. Yeah, I think it's a worthwhile goal.
Okay, so you'd rather keep it the way it is
Yeah.
in the bill? Okay.
Yes.
Cool. All right, thank you.
Yes, sir.
Questions? Representative
Sorry.
Ganadin? Amazing.
Yeah, there you go.
There you are.
Part of what we do, I guess, here at the legislature when we have these conversations is publicize the way we're thinking about moving forward as a state, thinking how we're moving forward with state agencies and communicating to the public our desires.
Yes.
So I guess it's fair to say you're communicating to prospective new recruits that we're looking to hire more women.
Yes.
Okay. Thank you so much for your years of service. How long have you served?
Well, okay, so I was with the Attorney General's office for like 32 plus years, and then they asked me to come help stand up the Department of Law Enforcement. So I've been with, a year ago this past December is when I joined the DLE. And anyway, then they put me through recruit school and along with my regular job, and here I am.
So would you say in those decades of service that the practice of law enforcement has changed in the way we react to people with behavioral issues, with mental health issues, and that kind of a thing?
Oh, yes. Yes, sir.
Would you say that women tend to, just because of how we are in our society, like tend to react to those behavioral issues differently than men?
Yes, so, and in the last bill, I talked about the in-service training and playing the person in crisis. And generally speaking, our women officers dealt with me much better when it came to the crisis intervention and the de-escalation. Yeah, there was a couple that, you know, just shot me right away, but generally, they as a group, very different in how they approach. I mean, I'm sitting there yelling at them and doing all kinds of things. It was very different, and you can see how they approach it. Even in the training of new deputies, when they pair them up, they think differently. I mean, you know, guys are dumb. We do dumb things. You know, they handle things differently, and having women on the force is an immeasurable value.
Yeah, there we go. All right, thank you.
Yeah.
Okay.
Thank you. Any other questions?
None.
If not, thank you very much. Appreciate your honesty and candid testimony. Let's move on to the next measure. House Bill 2425, relating to the Child Abuse and Neglect Central Registry, clarifies that a confirmed report of harm or threatened harm, as defined in Chapter 587A, or child abuse and neglect, as defined in Chapter 350, will result in the perpetrator's name being maintained in the Central Registry, clarifies when a confirmed report may be expunged from the Central Registry, and establishes a process for expungement upon request. First up, we have testimony from the Department of Human Services.
Good afternoon, Chair, Vice Chair, and members of the committee. On behalf of Director Betts, I'm Daisy Hartsfield, the Administrator for the Social Services Division. The department did submit written testimony in support of this administrative measure. Just for some background, the Central Registry it's a tool used to assess whether or not a person can be entrusted with a care for children or vulnerable adults. And the information is not publicly accessible. Child Welfare Services requires that individuals need to provide a signed consent to the department before releasing any information to a third party. And Child Welfare does not provide any recommendations as to how that information is used. It's up to the third party to analyze a person's fitness in the context of their request as provided by typically a particular employer in terms of meeting its industry standards and regulations. Currently, an individual has the ability to appeal having their name on the registry, and they can do it through an administrative appeal process or through the courts. This bill provides an administrative process for them to do so, and it also provides the department discretion to expunge an individual's record. And this bill is important because we recognize that individuals can change, they can be rehabilitated, and it can be a detriment for their name to remain on this registry. And we believe that this provides that ability, and I'm available for any other questions, or any questions. Mahalo.
Thank you. Thank you very much. Next, we have testimony from the Attorney General.
Thank you, Chair and Vice Chair and members of the committee. The Department of the Attorney General appreciates the opportunity to testify in support of this measure. We believe that getting on the registry, it has serious consequences for folks in the community. We want to make it very clear in law how you get on, what you can do to challenge to get off, and also create, for the first time in legislation, a process of expungement, even if you were validly put on the registry, that situations in your life have changed, you've grown, you've made progress, and you no longer belong on that registry based on where you are now versus where you were at the time you were validly put on the registry. So thank you for the opportunity to speak in support, and I'm available to answer questions.
Thank you very much. Next, we have testimony in opposition from the Hawaii Coalition for Hawaii Coalition for Child Protective Reform, Marilyn Yamamoto. And we also have testimony in opposition from another member of the same organization, Nonohe Botello. No. And then finally, testimony in support from Dara Carlin. Anyone else wishing to testify on House Bill 2425? If not, questions, members? I do have a question. Department of Human Services. Thank you very much for being here.
You're welcome, Chair.
Do you assist, would you be able to provide to people who are interested in pursuing expungement legal support? Or would they be able to get a court-appointed attorney or public defender or anything like that?
Currently, that is not something that is available, unless that their case is moving through the court system. So if the department files a petition, then they will be appointed an attorney to represent them. However, for administrative appeals, they would have to seek legal counsel if they want legal representation. So that's the current situation.
If that's for administrative appeal, they have to hire their own counsel. Do you have a list of attorneys that do that kind of work that you could provide to the individuals so that they would be able to get started and find somebody?
We don't have a list. We usually will refer them to legal aid or to other indigent legal services that may be available.
And do they have people in legal services or legal aid that do this sort of work?
They do, but they would have to submit an application and meet their eligibility requirements to receive representation. We do have situations where people do have attorneys privately retained that represent them in these administrative hearings.
Okay. Okay, are there, the Hawaii Coalition for Child Protective Reform, in their testimony, said that they had submitted, they got a chance to review it, and then they submitted comments to you. They feel that that nothing was changed to address their concerns. And I guess their concerns, in summary, are that there's a serious lack of due process, and they feel like most parents have no idea that the registry exists prior to making a decision to stipulate or contest the allegations. Most people can't afford an attorney, so there's no provision for court-appointed lawyers. Could you describe, I mean, I think you're familiar with some of their concerns. Could you describe how this bill is set up in order to, at least in some part, address their concerns?
Sure. And first of all, let me share that we have been having open discussions with them, so I'm aware of their concerns, and I believe that fundamentally the difference in terms of due process is that they believe that a person should not be placed on the registry once a confirmation has been made. They believe that there should be a process where they can appeal first before their name should be placed on the registry. So I believe that's why they disagree in terms of whether or not due process has been met. In terms of, I forgot, there were two other issues. Due process was one. The cost for legal representation, I believe your question had answered that. And I'm sorry, Chair, what was the
Most
second?
parents have no idea that a registry exists
Yeah.
prior to making a decision to stipulate or contest
And,
the
and
allegations.
I believe they take on that position because the department provides a letter to parents. Well, first of all, they're verbally informed that there will be a confirmation and that their name will be placed on a registry. And then they receive a letter notifying them of that disposition and what they can do to have that decision reconsidered. But that letter is a very simple one, so my belief is that parents may not understand the seriousness of it. They may hear it, they may acknowledge it, but they don't really experience the consequence until there's actually a query into the registry and they're unable to secure a job. So I disagree that adequate notice is not provided, but I can understand why the coalition would take that position.
Have you looked at possibly changing the language in the notification letter so it's clearer?
What we are doing is trying to train our workers better so that there's better understanding that parents have in regards to the registry. We're also we've had discussions about training attorneys so that when they represent parents, that they also are aware of the consequence of a parent stipulating to the court, to the department having jurisdiction or foster custody over their children. And we have relooked at the letter, but at this time there's no discussion on whether or not it should be reevaluated or redone.
You mean the changes in the language?
Correct.
Yeah. Thank you. Well, I would encourage you to continue your conversations with the individuals who are with the Hawaii Coalition for Child Protective Reform and continue your work to try to address their concerns. I appreciate what you've done so far, but please continue.
Will do. Yeah. Thank you, Chair.
Any other questions, members? If not, let's go on to the next measure. House Bill 2058 relating to dangerous dogs. This bill establishes requirements and penalties for owners of dangerous dogs. It allows for impounding of dangerous dogs under certain conditions. First up, we have testimony from the Attorney General's office. Welcome. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee, Kelsey Nagata, Deputy Attorney General, providing comments on HB 2058. As stated in our written testimony, the bill may be subject to challenge under the Due Process Clause of the Constitution because there are presently no measures that would provide the dog owner to challenge any actions taken against them. We have provided a few ways that this may be remedied in our testimony. Specifically, there should be an avenue for the dog owner to challenge the designation of dangerous dogs and the potential impoundment of the dog. I will be available for any questions. Thank you.
If I could, before you leave, in the rest of your testimony, it says in regard to potential due process issues for Section 142, it may be effective to conform the bill to the wording in Sections 711-1109.1 and 711-1109.2 HRS, which provide authority and processes for impoundment and forfeiture of animals in connection with the cruelty to animal offenses. You'd be happy to assist in the drafting of appropriate due process provisions. Just so I'm clear, have the suggestions you made in the other paragraphs above that addressed what you talk about in 711-1109.1 and .2, or is that you're suggesting we need additional language that you would help us out with writing?
The additional language that we would be happy to assist in writing.
Okay. Okay, thank you.
Thank you.
Okay, next we have testimony and support from Keldon Walchin, Hawaii County Office of the Prosecuting Attorney. Please proceed, Mr. Walchin.
Can you hear me?
Yes, now we hear you. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and committee members, Hawaii County Prosecuting Attorney Keldon Walchin. Our office stands in support of this bill, and I thank Vice Speaker Ilagan for his efforts in introducing this legislation. This bill is a step in the right direction to address growing concerns surrounding dangerous dog attacks and holding irresponsible owners of dangerous dogs accountable and protecting people in our community. Currently, we do not have an applicable statute at the state level to hold an offender criminally responsible for negligently causing the death of another person. This issue hits too close to home for me and my family Back in August 2021, my aunt, my uncle, her husband, and my other uncle were all attacked and by their neighbors' dogs. My auntie was killed, and both my uncles sustained serious injuries. Hawaii County officials, including HPD, Corporation Counsel, District 4 Council member Kirkowitz, and our prosecutor's office all recognized the need to create a law with appropriate felony penalties. In April 2022, Hawaii County Council passed Bill 125 into law as Hawaii County Code 4-4-32. HCC 4-4-32 attempted to create felony level penalties for dog attacks, which resulted in substantial or serious bodily injury or the death of another person. Unfortunately, much to the dismay of Hawaii County law enforcement, county officials, victims and their families, and our community, we all learned that the felony penalties are not enforceable because they are preempted by existing state law. As a result, at this time, under our current county code, the most serious penalty related to a dog attack resulting in death is a petty misdemeanor. Consequently, our hands are tied. Since my auntie's death, we've had subsequent dog attacks where other victims have lost their lives. My thoughts and prayers go out to them and their families. That is why we're here today. Our community has made it very clear they want to address this issue. Please take a look at the data our office gathered in our 2021 legislative survey, which was relied upon in the passing of Bill 125 and is attached to my written testimony here today. An overwhelming majority, over 81%, supported legislation to enact more serious penalties for dog attacks resulting in serious injuries or death. Also, it has come to my attention that these concerns are not just a Hawaii Island centered issue, but are also shared across our state, with the Hawaii State Association of Counties recognizing this issue as their #1 legislative priority this session. We hope that this legislation will not only hold offenders accountable, but more importantly, deter and inhibit future incidents by encouraging dog owners to take appropriate measures to secure their animals. I feel for the victims, I feel for those who have been named, and for those who have lost their lives. I feel for their families and their friends. Let's work together to ensure public safety, remember the victims, and protect our communities. Mahalo for the opportunity to testify today and for your consideration. We submitted our written input, and I'm available to answer any questions. Mahalo.
Thank you very much, Mr. Welchin. Next, we have testimony support from the Hawaii Animal Welfare Association. Stephanie Kendrick.
Thank you, Chair Tarnas, Vice Chair Takayama, committee members. Stephanie Kendrick for the Hawaii Animal Welfare Association. Hawaii Animal Welfare Association represents the largest animal welfare organizations on all 4 counties and most of the animal law enforcement interests in the state. We're working on getting Hawaii Animal Control as a member. But our members are in strong support of this legislation as part of their responsibility is keeping the community safe. And our present dangerous dog laws, which are situated at the county level, are simply inadequate. This bill would help us do 2 things. As Mr. Welchin quite eloquently pointed out, it would provide appropriate penalties for the most egregious of these attacks. It would also give us some tools to help prevent attacks from happening in the first place. And I urge you to pass it. Thank you so much. We also, suggested some minor amendments in our testimony that were gathered from the real animal law enforcement experts in the 4 counties. So I hope you'll take those into consideration. I don't think they substantively changed the bill. Thank you.
Okay, thank you very much. I see you're also listed as giving testimony from the Hawaiian Humane Society.
Thank you, sir. Stephanie Kendrick from the Hawaiian Humane Society in support of this measure. You know, as an animal welfare organization, this is a tough issue for us. We would rather all dogs be happy, well-adjusted, and have a loving home. That's not always the case. And as a 140-year-old organization that's committed to our community, part of our role is also keeping that community safe, and we take that role very seriously. We think that this measure really balances the interests of animals, pet owners, and the community, and will help us do that. And we absolutely respect the AG's call for a review process for the dangerous dog designation, and happy to work on language. We've had some preliminary conversations with county law enforcement about what might not work, but hopefully we can find something that does. I would hate to see that hold up this measure. But thank you to the sponsor, Representative Iligan, and to the committee.
Thank you very much. Next, we have testimony and support from Michael Konowich. Testimony and support from Aloha Animal Advocates. Testimony in opposition from the American Kennel Club. Testimony with comments from the Pacific Pet Alliance. Testimony and support from the Hawaiian Humane Society. Testimony and support from Americans for Democratic Action Hawaii. Testimony and support from Animal Interfaith Alliance in Britain. Testimony and support from numerous individuals, and some of them may be on Zoom. Is Loke on Zoom? Please proceed. Was it? Oh, okay. Loke, when you get back. Oh, she's on now. Okay, please proceed. You could turn your microphone on and turn your camera on.
Got him.
Oh, there you are. Please proceed. Introduce yourself and please proceed.
Thank you. I am in support of this bill overall.
Please introduce yourself.
My name is Loke Ke'ihana Kuakahi Hulihe'e Kahauna Ele Keana Aina. I come from the island of Hawaii. I've lived here for 32 years. I was a victim of a mauling. It was our service dog to my husband, who's a Vietnam veteran, who suffers from severe PTSD, and 3 dogs were abandoned across the street from us, unbeknownst to us, and left to guard a marijuana grow when the family moved away, and people were feeding the dogs but not tending to them. And they ended up digging underneath our fence and coming in and mauling my dog. And that's how I got involved in Bill 125. And because there were different circumstances that stopped the dogs from being dealt with. The dogs went back to the property. So this is kind of the definition of the dangerous dog, and questioning like how this can be handled. This mauling happened, the dogs run back to their place, they took the dogs away. And so there was no seizing of the dogs, there was no follow-up with animal control, there was nothing done. And these dogs still are alive, and I don't know their circumstances. And so the person gets away with it and the dogs continue to live. And so what I would really like to see is procedures on how to handle the dangerous dog when these incidences happen.
If you could please summarize, I appreciate your testimony, but if you could please summarize, that'd be great.
Okay, so procedures, proper procedures. The next thing is, it would really be wonderful if the law could include education and rehabilitation of owners of dangerous dogs. Yeah, because they're going to get another one, and it's like a person who has been abusing alcohol going through a rehabilitation. A lot of us believe that people need to go through some kind of a rehabilitation. And I'm wondering about the petty misdemeanor for refusing of relinquishing a dangerous dog that is subject to relinquishment. I would really like to see that a stronger penalty than just petty misdemeanor. And so, yeah, those are just some other issues that need to be addressed, in my opinion.
Thank you.
Thank you very much, and I do support this bill.
Thank you very much. I appreciate your testimony. Next, we have testimonies in support from Shannon Matson. Are you on Zoom? Please proceed, Ms. Matson.
Thank you. Aloha, Chair, Vice Chair, and committee members. I'm Shannon Matson, and I'm a lifelong Hawaii Island resident. First, thank you all so much for prioritizing hearing HB 2058 today. I know that a lot comes across your desks, but I can assure you this is an important issue to many, as you can see by the overwhelming and diverse testimony in support. I want to say that I agree with the Attorney General about including options to contest or appeal. But to add to that, I really don't want to see animals languishing in our already overcrowded animal shelters. So I urge you to please make certain that whatever process you include for appeals be a speedy and efficient one. Also, I do agree with the Hawaii Animal Welfare Association. They're important but clarifying proposed language amendments. I think I would appreciate it if you could please incorporate those into your next draft. Testifying today is simultaneously the worst and best way I could be spending the 6-month anniversary of my dad's death. HB 2058 is an overdue correction to a shocking oversight to a preventable problem that just keeps getting worse. Dog attacks and dog deaths are increasing in severity and occurrence for several factors. One being that we have more people and more dogs here than ever before, and another being that our culture currently treats dogs as a replaceable throwaway rather than members of their family. Excuse me, Chair, sorry. I'm gonna try to get through this as quickly as I can. My father instilled animal welfare values in me as a young child. We were always rescuing animals, bringing home stray cats, chickens, goats, and yes, stray dogs. In all of my years of animal ownership, we have never been bit by one of our pets, and we have never allowed our pets to roam free and to bite others. Pet ownership is a responsibility and a privilege. My father was an animal lover and even had a puppy that he had recently rescued from a bad situation living at his property at the time of his death, which we have since adopted and given a new home to. It's exhausting to have to try to navigate the system while also navigating grief. It still doesn't feel real to know that my father was killed while walking to catch a ride from a friend. It's horrific to imagine the level of fear and pain that he must have experienced in his final moments. In these 6 months since his death, we have found no justice. The dogs that attacked him were confiscated and, to my understanding, were put down, but the humans who allowed these animals to be in this horrific situation in the first place have faced no accountability or consequences. It's an injustice, not just for our family, but in the memory of all of those whose lives were lost and or greatly affected by dog injuries and deaths in the past, who fought for legislation at the county level, and it passed in 2020. The law passed, and yet they are being re-traumatized now as they are witnessing the fact that the law that they worked so hard to pass is actually worthless. I'm sure as legislators, you must understand the frustration in that. Something the community came out for and spent countless hours working on, only to find out that it actually does nothing. I don't understand how this mistake could have been allowed to happen in the first place. And my understanding is that we need change at the state level now to correct it. It's a horrible mess. It needs to be straightened out. I implore you to please pass this bill and make absolute certain that when you do, it is a law that can be enforced. Make sure that it is in alignment with our county bills that call for the option to prosecute certain cases as a Class B felony level. Our communities need this to feel safe again. Our keiki and kapuna deserve this, and our pets deserve this. This is just the first step in changing a culture of dog abuse and neglect. We also need enforcement and education, but HB 2058 is an absolutely necessary step to ensure that there are laws that can be enforced. And if, heaven forbid, this happens to future families and they go through a similar loss, they will not be faced with the same runaround that our family has been, but instead will receive the swift justice that they rightly deserve. Mahalo for your time.
Thank you very much, Ms. Mattson. Please convey our deepest sympathies to your entire family on the loss of your father. It's a tragedy, and I appreciate you taking that tragic experience and trying to make the world a better place so others don't have to go through this. So thank you very much.
Thank you, Chair. I'll be available for questions.
Thank you, Ms. Mattson. Next, we have testimony and support from Alexis on Zoom. Is Alexis on Zoom? Nope. Testimony and support from Deborah Ward on Zoom. Please proceed, Ms. Ward. If you could turn your microphone on and your video on and proceed.
Yes. Aloha, Chair Tarnas, Vice Chair Takayama, and legislators. Apparently, as I unmuted, someone else unmuted at the same time and remuted me. Anyway, thank you for your work.
Thank you.
My name is Deborah Ward, and I'm a 60-year resident of Hawaii, and this bill needs your support. We have sadly experienced Hawaii County residents whose lives have been tragically and violently cut short by vicious dogs whose owners failed to secure their animals. Other residents, such as a 9-year-old girl walking home from school, have lost an eye, a limb, and experienced severe trauma. My dear friend just lost her father to a pack of 4 dogs in a local subdivision, and I met a woman recently who's now paralyzed and wheelchair bound due to an injury caused by a neighbor's dog that leapt over her fence. I also have a personal reason for asking for your support on this matter, and I have a farm growing ulu, kalo, bananas, cacao, and citrus. And in 2014, I was working on my farm when 2 pit bulls owned by guests of my neighbor entered my farm unleashed and knocked me to the ground. One bit my legs and created a gaping hole in my calf and thigh. The other went for my face, but I fended him off with my arm. And that dog broke open my arm, shook his head violently, and broke the bones in my hand and finger. 9 years later, I'm still unable to use the fingers in that hand. Because there was the possibility that I would be suing and therefore putting payment in jeopardy, Queens Hospital refused to take me, even though I was prepped already in the helicopter. For the same concern, Haleʻanui refused to allow me to receive occupational therapy there. So I had less than optimal repair surgery and expensive self-pay therapy, none of which was reimbursed by the neighbors or the dog owners. The dog owners experienced 0 penalties. I'm glad that you added a measure of required monetary compensation to the victim or the family for these injuries and manslaughter events. And remember that victims that are not killed still have painful, life-changing, and very expensive outcomes. As to amendments, I don't believe that a fine of $1,000 would be a sufficient deterrent, and I urge a larger fine. I think in this day and age, $1,000 is spent in a month on care and feeding an animal, and I think that a larger fine would be a better deterrent. So thank you very much for supporting this bill. I encourage you to follow through with the AG's advice, but I'd also like to be informed of the next measures so that I can support this bill as it goes along. Thank you so much.
Thank you very much, Ms. Ward. Next, we have written testimony and support from approximately 90 individuals. 90 individuals, and testimony in opposition from 3 individuals. Is there anyone else here or online who wishes to testify on this measure, House Bill 2058? If not, questions, members. Representative Iligan, Vice Speaker, please proceed.
Thank you, Chair. The Office of AG, Kelsey Nagata. Thank you. First of all, I want to say thank you for your written testimony. These amendments are what's missing in this bill. So the first one, I understand, adding that amendment will definitely help with an appeal process for the dangerous dog designation. In regarding to impoundment, after reading section 711-1109.1 and .2, I noticed that if we integrate those sections, is it possible to actually eliminate and gut a lot of the pages from 12 to 17 because that process is already in those sections?
I guess I'm wondering what your question is. If you're saying that you're going to be contradicting what's already written in the penal code, is that your question?
No. My question is to integrate those sections that you mentioned in your testimony.
Yes.
So those 2 sections
yes.
that I stated. Looking at the existing bill.
Yes.
I wanted to ask you, after taking it into the bill, do you think much of the language that's in these pages from 12 to 17, should we keep it in there, or should we remove it? Because a lot of the provisions are already in those sections that you mentioned.
It's completely up to the what the committee would like to do in terms of keeping or removing language. if the language is, that's why we recommended looking at the two to determine which the committee prefers and what language to keep in order to either conform or to create something brand new. So we'll be happy to help with the legality of that. But in terms of policy, that's up
Would
to
you
the
be
committee.
able to give us a breakdown of what's different in this language and what's in those two sections?
I could compile something and get back to you on that. Yeah.
Thank you.
Any other questions? Okay. Thank you very much. Any other questions, members? If not, let's move on to the next measure. House Bill 2457, relating to the Department of Law Enforcement. This expands the requirements of Section 353C-9 to require the Department of Law Enforcement to pursue and obtain accreditation from the Commission on Accreditation for Law Enforcement Agencies, Inc., for all divisions and sections within the Department of Law Enforcement. It establishes 5 coordinator positions for this Commission on Accreditation for Law Enforcement Agencies, exempt from civil service within the Department of Law Enforcement to ensure the department meets and maintains the standards set by the Law Enforcement Standards Board and accreditation of the Commission on Accreditation for Law Enforcement Agencies. First up, we have testimony from the Department of Law Enforcement. Welcome, Deputy Director. Please proceed.
Thank you. This is an administration measure. 353C9 requires just the Sheriff's Division to be CALEA accredited. If the Department of Law Enforcement is expected to be a law enforcement department, a true police department, we felt that all of the divisions need to be required to go through CALEA accreditation. And that's the reason for the bill, is that we want to expand it to the entire department, not just the Sheriff's Division. And the positions are needed. CALEA is more than just a process of trying to get accredited. It's an ongoing effort to make sure that policies, forms, training, all of the practices remain up to standard so that you remain accredited. Until Hawaii gets a peace officer standardized training requirements nationwide, this is the best thing we can do, is to move this direction. And that's the reason for the bill, sir.
Great. Thank you very much. Appreciate it. We also have testimony and support from Charles Walton. Is there anyone else here wishing to testify on House Bill 2457? If not, questions, members? Mr. Vincent, if I could interrupt you just a moment. Sorry. Yeah, it's all right. Oh, yeah, thank you.
Yes.
Well, thank you very much, Ms. Goliu.
Yes, sir.
Vincent, from our reading of the bill, the substantive provisions of the measure, specifically Section 4, do not actually specify that these CALEA coordinator positions are to ensure DLE meets and maintains the standards and accreditation of the Commission on Accreditation for Law Enforcement Agencies. So would you object if we work on the language to try to make sure it's very clear that that's in fact their job?
That would be fine.
Okay.
Yep.
Okay, great. Thank you. Any other questions on House Bill 2457? Oh, yes. So, sorry, one more thing. I appreciate support from my staff who's wanting to ask about the status of the Law Enforcement Standards Board and what work is being done to provide uniform standards across all law enforcement agencies.
I don't know. I just look at their legislative reports, and it looks like they're trying to move that direction. I don't know where they're at. I'm not involved with that board. Deputy Director Radula is actually on the board, but he's not here.
He's not here, yeah.
He's not here.
So maybe as this bill moves forward if the committee so chooses, and we do decide to move it forward, it goes to Finance Committee, and I think if they choose to have a hearing on it, I think we need to learn more about the Law Enforcement Standards Board, what its status is, what's being done. So maybe if Mr. Radula might be able to check and make sure he's got those answers, just in case he's asked, I think that'd be great.
Okay. Yes, sir.
That'd be great. Thank you, sir. Any other questions on 2457? If not, let's move on to the next measure, which is House Bill 2461, relating to Homeland Security. This establishes the Cybersecurity, Economic, Education, and Infrastructure Security Coordinator within the Department of Law Enforcement and amends a section of HRS that's relevant. First up, we have testimony from Department of Law Enforcement.
Thank you again. Another administration measure. The position is actually already established in 128.1, section 128B1, I'm sorry. And what this does is it exempts the position and then specifies that it's the director that appoints the position. It's just so that we can get a qualified individual in here to serve in this really important position to coordinate the cybersecurity, economic, education. There's a lot of things with this position, and it works with the Office of Homeland Security and the Hawaii State Fusion Center.
Okay, so the purpose of the bill is really to exempt this existing position from civil service and that the director appoints the position.
That's correct, sir.
Got it. Okay, great, thank you. Anyone else wishing to testify on this measure, HB 2461? If not, questions, members? Nope, seeing none, we'll move on. House Bill 1953 relating to the Penal Code. This requires the Judicial Council to conduct a comprehensive review of the Hawaii Penal Code and to recommend proposed changes. Requires the Judicial Council to appoint an advisory committee to assist in the review, allows the council to also appoint a reporter and other staff as necessary, and requires the advisory committee to report to the legislature, makes an appropriation, and declares the general fund expenditure ceiling is exceeded. First up, we have testimony from the judiciary. Anyone here from the judiciary with comments? Next, we have testimony from the Department of Corrections and Rehabilitation. Yes. Thanks for your patience. You waited all this time. Appreciate it. Thank you.
Good afternoon, Chair, Vice Chair,
proceed.
members of the community. I'm Frank Young, Division Administrator, Intake Service Center, Department of Corrections and Rehabilitation. I'm here to testify for Director Tommy Johnson, who apologizes for not being able to be here. But we basically support the intent of this bill. And we feel, for our written testimony, that it is imperative that having effective, fair, and balanced penal code will be done by the review process. But we do defer to judiciary on advisory committee issues and concerns. So, thank you for the opportunity to provide testimony.
Certainly, thank you very much. Is there anyone, let's see, we have Kat Brady, Community Alliance on Prisons. Welcome, please proceed.
Aloha, Chair Tornes, Vice Chair Takayama, and members of the committee. Kat Brady testifying on behalf of Community Alliance on Prisons. We strongly support this bill. I represented CAP on the 2005 Penal Code review. This is really important that we review this periodically and that it has a broad cross-section of the community, and I appreciate this bill. Thank you so much for introducing it, Chair.
Thank you very much. Is there anyone else here or online wishing to testify on this measure, HB 1953? Not questions, members? Nope. Okay. Before we move on to the next measure, I'm going to beg the indulgence of the committee, go back to the previous measure, 2457, since Mr. Radula has returned. I wondered if you might have the information, since you do work with the Law Enforcement Standards Board at least a little bit, on behalf of the department. Would you be able to help us understand the status of the Law Enforcement Standards Board and what work they are doing to provide uniform standards across all law enforcement agencies? The bill that this was regarding was requiring the Department of Law Enforcement to pursue and obtain accreditation from CALEA.
Thank you, Chair. To be clear, this afternoon I'm testifying on the behalf of my department.
Of
However,
course, yeah, but you, on behalf of the department, you
yes,
are
that's
involved
correct.
with.
Yes, right now the Law Enforcement Standards Board rather is in the process of hiring an administrator as well as its administrative staff. There's a lot more work that has to come into play with the board. including things like Chapter 91 rulemaking and those kinds of things as well.
So they still have to hire key personnel and still need to promulgate their rules?
Yes.
Got it. Okay, so they're really not able to do anything just yet on trying to provide uniform standards across all law enforcement agencies?
Certainly, that's the goal that they're working towards, but it is a process that they're doing.
Okay, great. Thank you for telling us the latest status.
All right, sir.
Appreciate it. Okay, let's move on to our last measure on the agenda relating to firearms. This is House Bill 2622. This measure appropriates an unspecified sum to the Department of Law Enforcement for the state's gun buyback program. And it declares that the appropriation exceeds the state general fund expenditure ceiling for 24-25. First up, we have the Department of Law Enforcement.
Good afternoon again. So this bill, the gun buyback program was a success on Oahu. What we'd like to do is we would like to push it out. We'd like to do a couple buybacks on Oahu, 2 on the Big Island, Hilo, Kona, 1 or 2 on Maui, 1 on Kauai. There is a large interest in us doing this. And the funds that we're looking at would allow us to continue with the program and expand it. One of the things we did with this prior one was actually purchase Foodland gift cards. We try to keep the money in the community so that it stays in the community. The firearms that were confiscated was almost 500 firearms. And I know there's a lot of controversy with the program, but the reality is there's a good interest in the community to turn in these firearms. And a lot of them are, it was clear during that day that a lot of them were firearms that, probably left over when Dad passed away and Mom or the kids weren't quite sure what to do with them. I know I went and picked up some firearms from a retired police officer, and he was in his 80s, and he didn't want to leave them for his wife to have to deal with when he passed away. And we clearly had some that were illegal in nature. Measures are taken to make sure that all of the firearms are destroyed. All of them are run through the system to see if any have been reported stolen. And people that have reported firearms stolen, if they're in the batch, they actually reach out, try to contact them and see if they want them back. So it's kind of a good program, but there is a large interest in it. And we're asking for $825,000 to help us fulfill the program. And that takes care of buying the cards, the storage, the disposal, the overtime for the law enforcement officers that are supporting the drop-off sites. Last one was on Saturday. It's probably going to be the same thing the next time we go around, but it's trying to get the county officers also involved with us, and we had a great partnership with HPD who worked with us on the last one. Thank you.
Okay, thank you very much. Next, we have testimony from the Hawaii Firearms Coalition. Mr. Roberts. Please proceed, Mr. Roberts.
Hi, good afternoon, Chair, Vice Chair. We don't feel that a buyback is a good way to do it. I did written testimony and I provided an alternative, which would be by allowing people to do the same thing but via the county police department. We're spending $800,000 estimated to bring in these firearms to hold these special events. Why aren't people able to dispose of these firearms year-round? Why isn't there a program that would just allow the counties to handle this locally? It would be a much better thing for the counties just to say, drop off your firearms at the police department, no questions asked, 365 days of the year. We've seen on Oahu that the buyback program created a lot of traffic. It took officers off the street to do that. Police department is a much more secure location to do this. We feel that that would be a better situation. My written testimony provides an outline of kind of what we feel should happen. It's pretty comprehensive, and with a shortage of police officers, do we really want to take police officers off the street, law enforcement off the street, to take firearms from people that are typically not used in crime? We're saying that this works, but yet here we are on Oahu with more gun crime this year than we've seen previously, but we've taken 400-something guns off the street. So I just feel, and the organization feels that it could be better spent and a better system could be put in place, and that's something that we should probably look at rather than just doing a periodic buyback. Thank you for your time.
Thank you very much. I appreciate your testimony and detailed suggestions on what looks like a very a different approach, a different bill. But thank you very much for that thoughtful testimony. Okay, let's move on to Mr. Michael Rice on Zoom. Please proceed, Mr. Rice.
Hello, Michael Rice, speaking on behalf of myself. I do have just comments on this. As Andrew suggested, this should not just be a periodic buyback. I've put suggestions in my own testimony as to how this should be done, which would hopefully reduce the amount of money that's spent by taxpayers on a program such as this. It would now include like guns which are illegal to sell, otherwise not reported stolen, not on a machine gun or otherwise illegal. Somebody shows up with an Uzi scratched off, they can't just take it to a gun shop. My suggestion was to make it so that the police would hold on to these firearms when they're turned in, because right now it's really a hassle to try and do these things through private sales. They would then give the person who turned it in a sign out or forms saying that, okay, you have this model, this caliber, all this, which they can then take to a gun store, a legal gun store, and approach them and say, hey, I would like to sell this. Because during the buyback, I've seen a lot of pictures of those firearms, and people were getting $100 gift card, a day of groceries for a weapon that I would easily spend $1,000 on just because it's an old historical piece. So they're not getting the value for their firearms. But I do agree with the intent of the program, because it does, like I said, if somebody doesn't know what to do with the gun, they're just gonna have it in the safe until some grandkid comes across it or somebody steals it. So I would like to encourage this, but I believe that there would be a better way than just to spend taxpayer money and still allow people to get the value out of their property. Because as I was saying, it's rather difficult if you're an inheritor of a firearm to sell it, because one, you need to show that you are the owner of the firearm and the registration, which is difficult because some of these predate the registration requirement.
Thank you.
And, all right, thank you.
Thank you very much. Appreciate that, Mr. Rice. Next, we have testimony from Mr. Todd Yukutake. Please proceed, Mr. Yukutake.
Aloha, Chair and Judiciary Committee. Todd Yukutake, provide comments. I support the intent of this bill. Looks like there's a demand for it, which was obvious from the last turn-in. But I disagree with the cost of the program. $825,000 might seem just like a drop in the bucket for the state budget, but just feels a little excessive as a taxpayer. And I don't think it's necessary. I think people just want the peace of mind of letting the guns go and not, having to deal with an interrogation by the police. I think there's a better way to do it that doesn't cost as much. People can turn the guns to the store, where the store, they have two options. Basically, they can sell it or do a consignment sale with the store, where both parties make money off of it, and you don't have to get rid of the gun. It's still a useful item. The other option that the gun store can provide is for the person to give the gun store the gun with no questions asked, and later on the police pick it up from the gun store, for destruction or turn-in. That way the person turning it in, they don't have to deal with the police. Some of them might still be afraid of the police, so might not be as intimidating to them. And I think by doing it this way, the cost is going to be much lower. And like I said, it provides benefit to the gun store to do the program, and for the owner to get more money out of it, and for the taxpayer too. by saving money. Thank you for your consideration.
Thank you very much, Mr. Yukutake. Next, we've received written testimony from numerous individuals, 1 individual with comments, 10 individuals opposing this, and 2 individuals supporting it. Is there anyone else here or online wishing to testify on this measure? If not, questions, members? Representative Ganadin.
Sorry, to the department.
Yes, sir.
I believe this fall's last gun buyback program was funded by the federal government.
I know some was from governor, some was from the federal government. Yeah, there's a couple pots of money, I think, involved in that.
So were we to pass this out, this would give your department an opportunity to further partner with county police in doing this, say, for how long?
Like I said, it would be the year. What we'd like to do is a couple more on Oahu, a couple times a year, 2 on the Big Island, 1 or 2 on Maui, and at least 1 on Kauai. Just see how they go, but it would be an opportunity to do what you said, partner with the county PDs, which is something that we have been doing and look forward to doing.
Okay. Maybe you or Mr. Rodella might be able to answer. What kind of firearms did you get when you did this event?
We got from all spectrum. So people were trying to turn in air rifles, BB guns, pistols, and rifles. We would not take air rifles or BB guns. There was old antiques, clear up to the most modern things that you can run down and buy. And as the one, it was Mr. Rice. There were some beautiful firearms turned in. I mean, thousands of dollars for some of these. And some of them clearly belong in a museum. I'm tasked with acquiring things for our department, and one of those is firearms. And one came in and told the boss, "Hey, I need to buy like 30 of these. Can I just use it?" No, it's getting destroyed. So even though we could use it, it was still being destroyed. The firearms that I picked up, one of them was brought back from World War II. It was a museum piece. It was actually in one of the news clips. But a wide range. Some of them were really old, rusty, and needed some work. Most of them were operable. There was some ghost guns. There were some guns that were clearly illegal in nature. But it ran the entire spectrum that you could think of with respect to the types of firearms that were turned in.
In the governor's State of the State address, you mentioned an Uzi.
There was an Uzi, yes.
Also, several guns with illegal silencers.
There was, yes.
All right. Thank you.
Yes, ma'am.
Please proceed, Rep. Souza.
Just a quick question. How many were actually illegal guns out of the total amount collected? Do you know the number?
Yeah, there were probably at least 40 or 50 guns that were clearly illegal.
And what was the total number from the last?
About 500 that was turned in. The illegal guns included things like absolutely ghost guns came in. Additionally, we had some sawed-off shotguns, as well as there were weapons that were threaded to accept silencers and things like that. So those kinds of weapons were also recovered.
Thank you.
Thank you. Other questions, members? I have a question. If the committee decides to move this bill forward, it still has a long way to go, and it's a big chunk of money, and we don't have much money this session.
Oh, I understand that, sir.
So I think that there's some really good ideas we heard from Mr. Roberts, Mr. Rice, and Mr. Yukutake. I would urge you to review their testimony, check in with them, and see if there's any way you can incorporate some of their ideas. I think I don't know enough about it to be able to tell you which ones are good ideas and which are doable and which are not, but I think I would just urge you to take a look at those even while we're moving forward on this measure if the committee decides to advance it.
First one I took, look at testimony for ideas, settle in normal course. And there need to be changes for that to be able to legally happen, but yeah, we'll take a look.
Would you please? And if to implement some of these ideas that Mr. Roberts, Rice, and Yukutake have recommended, if it does require some statutory changes, you know, come talk to me, come talk to Vice Chair or Representative Ganadin. We're very interested in this sort of thing to try to figure out how to make it work better. And if there's some innovative ideas, but require some statutory change, let us know. So please take a look at those and let's see if we can use some of these good ideas that we're getting in testimony here.
Yes, sir.
Great. Thank you very much.
Thank you for the opportunity, spending the afternoon with you.
All right. Well, I appreciate you being here. Any other questions, members? If not, thank you to all the testifiers here in person and online for your testimony. Let's move right into decision-making on these measures. Back up to the top of the agenda. Okay, first up, we have House Bill 2193. First, I want to commend Department of Law Enforcement for their great work, collecting 150,000 pounds of illegal fireworks in 3 months. Keep up the great work, keep going. We want to help you continue to be successful. So on this measure, I recommend that we move it out as a House Draft 1. Because it's got an appropriation, the Finance Committee has asked us to defect the effective date to year 3000, blank out the appropriation, include in the committee report the request for 1.2 million, incorporate the recommended amendments from the, and I would like to incorporate the recommended amendments from the Department of Law Enforcement. And I would also like to include our staff will work, because I think there's some overlap between the new administrative inspection section on page 3 and 4 and the amendments made under section 3 of the bill on page 8. So we'll try to straighten that out as well. So those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2193 with amendments. Chair and Vice Chair vote aye. Representative Evslin. Representative Evslin.
Has just arrived.
Representative Ganadin. Aye. Representative Holt excused. Representative Ichiyama excused. Representative Iligan.
Aye.
Representative Kong.
Aye.
Representative Miyake.
Aye.
Representative Souza.
Aye.
Chair, your recommendations adopted.
Thank you very much. Moving on to the next measure, House Bill 1888. On this measure, I would like to note that even in the testimony from City and County of Honolulu Police Department, they admit that although most of the fireworks being used are illegally entering Honolulu, a statewide limitation may lessen these unnecessary 911 calls. My opinion on this measure is that it's not something I want to move on right now. I want to defer this. I'm going to recommend deferral to the members. And the reason why is that if you look at what happened here in Honolulu with the ban on consumer fireworks that was done in, what, 2010? That there clearly remains a market demand that is going to the illegal market. And that if we pass this statewide, that's just going to be repeated in the other islands. And I would rather not do that. I would rather allow law-abiding citizens to continue with the process of getting a permit, getting their consumer fireworks. If the other counties want to change their ordinance so it's the same as Honolulu, they can do that. But I don't, instead of pursuing those who are legally using consumer fireworks, I would like us in the committee and the legislature to focus on interdicting illegal fireworks. And I want to support the efforts that DLE is doing right now. And so for that reason, I recommend we defer House Bill 1888. Questions or concerns, members? If not, let's move on. Thank you very much. House Bill 1865. On this measure, I recommend that we pass out an amended bill, HD1, Because this is an appropriation, as you're getting used to me saying this, our standard practice is to defect the effective date to the year 3000. It will be a blank appropriation in the bill, but we will insert into the committee report the request of appropriation of $747,267. $747,267.
Mentioned you turn any lens into a macro lens, and today I'm going to see how macro we can get.
Could you mute him? Thanks. So my recommendation is to pass out an HD1 with amendments as I've just described. Is there any questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 1865 with amendments, noting the excused absences of Representatives Holt and Ichiyama. Anyone voting with reservations or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Moving on to House Bill 1866. It's the same recommendation. Pass out a HD1, House Draft 1, defect the effective date to year 3000, keep the blank appropriation, put into the committee report the request for $736,785 to be appropriated. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1866 with amendments. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Moving on to House Bill 1968. I acknowledge what the Attorney General has requested, but I would like to move this forward because I agree I'd like to give the opportunity for people, if they so choose, to pursue a case, even after all these years. And so my recommendation is to move it forward with a House Draft 1. We need to make sure that it's clear in the bill language that the existing subsection time limits apply to assaults that occurred before July 1st, 2024. The new time limits would apply to post July 1st, 2024. So we want to make sure. We want to make sure that's clear in the bill. This is not retroactive. I know we've talked about that, but I just want to make sure it's clear in the language of the bill so people understand this is not retroactive. So that's my recommendation as a House Draft 1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1968 with amendments. Anyone voting with reservations or no? Your recommendation is adopted.
Thank you. House Bill 2230. On this measure, I would like to move out a House Draft 1. It's not finished yet, even though there's no appropriation in it. We don't exactly know how many days it's going to take for the program to be set up. So what I'd like to move it forward with a effective date in the year 3000. There is a blank in there that says how many days it'll take before they actually have a program set up. And I'd like to move it forward and put in the committee report the Department of Law Enforcement will work with the Law Enforcement Standards Board and determine together how many days it'll take to develop the program, so we can put in a number in there when it's before a future committee. If the committee does agree with my recommendation, it'll move on to Finance as the next hearing. So that's my recommendation. Oh, and I'll also include in the committee report encouraging the Department of Law Enforcement to work with the Office of Wellness in the Governor's Office to move forward on their program. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2230 with amendments. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Next measure, House Bill 2231. On this measure, at the strong encouragement from the Department of Law Enforcement, I'd like to move it forward as is. I think that it is it's a great aspirational goal, and you got to working toward it. It is a valuable exercise for all law enforcement agencies, and I appreciate your attitude about this from the Department of Law Enforcement. So my recommendation is to move this forward as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2231 passing as is. Anyone with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 2425. On this measure, I'd like to recommend we move out a House Draft 1 I would like to make some technical amendments. I would like to adopt the Attorney General's amendments and have the effective date be July 1st, 2025. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2425 with amendments. Anyone voting no or with reservations? Seeing none, your recommendation is adopted.
Thank you. On the next measure, 2058, my recommendation is to move out of House Draft 1, making technical amendments. I also, I would like to adopt the Attorney General's amendments, and I would like to adopt of the recommendations from the Hawaii Animal Welfare Association. There's under definitions, you're suggesting that serious injury to any animal as opposed to just domestic animal. This is on page 5, line 3. On page 7, line 13, add a couple adjectives before leash. So the dangerous dog is kept on a fixed and secure leash, no longer than 4 feet in length. Also on page 7, line 21, and muzzled with a, quote, properly fitted basket muzzle. And then for your final recommendation about placing sign or signs provided by the Animal Control Authority on the owner's premises informing the public of the presence and dangerousness of the dangerous dog, I would like to recommend that the Attorney General review this and work with us to determine if we can in fact include that, because it may be compelled speech and that may not be appropriate. So I am requesting that we adopt the other amendments that you have suggested, and if the Attorney General agrees that we can include your final recommendation, we'll include that. If they say it's compelled speech and not allowed, then we won't include it. So I'm going to thank the Attorney General for agreeing to work with us and move forward with those changes. And I think I mentioned we're also making technical amendments. So those are my suggestions. Oh, yeah. Also, in the bill, I also want to modify, it looks like the terms, quote, intentionally and term knowingly and the term recklessly are defined, but they're not even used anywhere in the bill. So I'm recommending we delete those. We're going to modify it slightly because it appears to be some overlap between paragraphs 3 and 5 under the definition of provocation. So we're going to make some technical amendments to correct that. Also, the term, quote, serious injury to a domestic animal is not used. The term should either be deleted or, if the intention was for the definition to refer to the language on page 10, line 3 or 4, that is, serious injury to or the death of another animal, we'll need to make some amendments to conform the language to these purposes. So we'll work with the introducer to make sure we correct those. So those would be the additional amendments to this. Questions or concerns, members? Passing out the amended version with those changes. If not, Vice Chair for the vote.
Voting on House Bill 2058 with amendments. Anyone voting with reservations or no? Chair, your recommendation is adopted.
Thank you. House Bill 2457. My recommendation is to pass out House Draft 1 with technical amendments. Also, we're going to make some changes to Section 4 to ensure that it clearly states that the coordinator positions for the CALEA, the CALEA coordinator positions, are to ensure that the Department of Law Enforcement meets and maintains the standards and accreditation of CALEA, which is the Commission on Accreditation for Law Enforcement Agencies, and that law enforcement officers of the Department of Law Enforcement meet the standards set by the Law Enforcement Standards Board. So we'll just make sure that that's clear, that that's the coordinator's responsibilities. We'll also make some technical amendments for clarity, consistency, and style. Those are my recommendations. Pass out HB 2457 with amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2457 with amendments. Any reservations or noes? Your recommendation's adopted.
Thank you. Moving on to House Bill 2461. My recommendation is to pass up a House Draft 1 with technical amendments only. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2461 with amendments. Any reservations or no? Your recommendation's adopted.
Thank you. House Bill 1953. I recommend we pass out a House Draft 1. We blank out the appropriations, include in the committee report the judiciary's request for $25,000, and defect the effective date to year 3000. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1953 with amendments. Any reservations or nays? Your recommendation's adopted.
Thank you. And final bill, House Bill 2622. My recommendation is to pass out a House Draft 1, have a blank appropriation in the bill, put in the committee report a request for $825,000, and defect the effective date to year 3000. Questions or concerns, members? Yes, Representative Ganadin.
Thank you, Chair. I'd like to just convey to the next committee that this is, for lack of a better term, good bang for your buck. You get, there you go. You get the police department's got 500 guns, dozens of which were illegal, any one of which could have been used in the commission of a crime. As we heard from the department, they have yet to do this program on neighbor islands, and it's a further opportunity to ensure no unnecessary deaths in our community. Thank you.
Certainly, at the risk of appearing to dampen your levity, I would just like to have it described as a very effective and efficient use of government funds.
I have a comment.
Yes, please, Representative Souza.
I don't typically diverge here, but
No, please.
But I will be voting no on this measure just because of the cost. I do appreciate the sentiment very strongly. I think that a gun buyback program is a good thing. However, I think there's other ways that maybe we can work this so we're not spending as many funds. And I'm not necessarily convinced that the guns being turned in are guns that maybe would have been used in the commission of a crime. So that's just my thoughts. Thank you.
Very valid points, and I appreciate that, Representative Souza. And in that regard, I appreciate Department of Law Enforcement's commitment to review the proposals from our testifiers and see what they can implement, because I think they had some very valid and useful suggestions. So I appreciate your comments, Representative Souza. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2622, noting the no vote of Representative Souza. Any other reservations or noes? Your recommendation's adopted.
Thank you very much. There being no further business before this committee, we are adjourned.